Okay, hello everybody. I believe everyone is here. Correct me if I'm wrong. Everyone has their partners. Yeah, great. Okay, so welcome. Before we begin, I would just everyone can hear me, right? Just making sure. Thank you. So before we begin, I'd like to remind our spectators that their microphone should remain off at all times. And for judges and participants, I would kindly ask you to keep your cameras on and your microphone should be on mute when you are not speaking. So all are present. Session W2 of the Walker-Moot Supreme Court is now in session. It is with great honor and privilege that I present Justice Katrina Crocker of Bennett Jones, Justice Ludmilla Jarda of Nelligan O'Brien, Payne, Justice Victoria Shore of Sheely, and Justice Valerie Calvano of BLG, presiding. So, justices of the panel, I present to you, speaking on behalf of the appellant, Ms. Armstrong. In today's matter before the court, we have Caitlin Simone and Theone Kapetaneas. Yes. And speaking on behalf of the respondent, Dr. Ward, we have Jillian Tanzer and Lauren Thompson. So we are here today to determine the outcome on appeal before the court on the matter between Ms. Armstrong and Dr. Ward. Both the appellant and respondent's counsel will have 30 minutes each in total, 15 minutes for each council member to present their arguments to the court, including answering questions from the bench. The appellants will present their arguments first, followed by both respondents, and then a 3-minute rebuttal will follow by the appellant. I will signal to the court when there is 5 minutes left per speaker using this card. I'll put it towards the screen. Appellants, will you be using your 3-minute rebuttal?
Yes, we will be.
The court now invites counsel for the appellant to begin. You may begin.
Good morning, good afternoon, justices. Thank you for your time today. My name is Theone Kapetaneas, and I, alongside my co-counsel, Caitlin Simone, will be representing Ms. Karen Armstrong in this case. This case is about the appropriate law under the standard of care in medical malpractice suits, but also about an individual woman, Ms. Karen Armstrong, who has been through an extensive amount of distress and harm due to the negligence in her surgery. Ms. Karen Armstrong has lost a kidney when she should not have needed to, and this should not be taken lightly. The appellant will be making 4 submissions today. I will be addressing the first 2, and my co-counsel will be addressing the last 2. The first submission we put forth is that the trial judge did not err in applying the standard of care in the way that he did, and therefore Dr. Ward breached the standard of care and should be liable. The second submission we put forth is that in some instances of negligence cases, causation can be used as circumstantial evidence to inform the standard of care, and the present case is one of these applicable cases. The third submission follows that non-negligent causes should not be the burden of the plaintiff. The fourth submission we put forth is that deference should be given to trial judges in findings of fact, and respectfully, this is not what occurred in this case. To address the first issue at hand, we submit that the trial judge did not err in applying the standard of care, and therefore Dr. Ward breached the standard of care and should be liable. The standard of care for specialist surgeons such as Dr. Ward is assessed in regard to the conduct of other specialists in that field, who, as per Terneuzen and Korn, possess a reasonable level of knowledge, competence, and skill expected of professionals in Canada in that field. So taken from the expert testimony in this case, it is agreed upon that the standard of care is to identify, protect, and avoid direct contact with or close proximity to the ureter when using an energy-emitting device like the ligature. According to expert testimony, close proximity is defined as 2 millimeters. So to begin, the requisite standard of this case is not meant to be a checklist that one tries their best to achieve, and respectfully, the majority erred in characterizing the standard in this way without reference to if the surgeon was accurate in taking the steps. I quote from paragraph 4 of the appellant decision. The majority states, Dr. Ward took the steps he described to identify and protect the ureter. These were essentially the same steps that Ms. Armstrong's own expert surgeon conceded a reasonably prudent surgeon would use. Given this finding, the trial judge should have dismissed the action. Further, the majority then did not highlight the need for accuracy when taking these steps. In paragraph 28 of the appellant decision, the majority states, if these steps were taken, including trying to stay a safe distance from the ureter, there would be no breach of standards. The key word here is trying. Given that the standard is to take these necessary steps, the success in taking these steps is essential. Trying to stay a safe distance is not the same as actually staying a safe distance. As cited by the dissent, Justice Van Rensburg, there's a difference between using the appropriate technique and executing it properly. Dr. Ward needed to stay 2 millimeters away from the ureter when using the ligature. Solely taking the steps to identify and protect the ureter respectfully should not result in absolving a surgeon of liability without a consideration of if the steps were taken accurately. The trial judge inferred that Dr. Ward did not stay 2 millimeters away from the ureter through relying on expert evidence. According to Dr. Hagen, had these steps been properly taken, there would not have been this type of injury, because during the surgery, you should not be anywhere near the ureter, you should be centimeters away. Relying on this evidence, the trial judge correctly found that Dr. Ward failed to take the necessary steps of staying away from the ureter and thus breached the standard of care. Furthermore, the majority respectfully erred in characterizing Justice Mulligan as imposing a standard of perfection in his standard of care analysis. Expert testimony addressed that the surgery occurred in ideal circumstances. Ms. Armstrong was said to be an ideal candidate for the surgery as there were no extra risks or potential complications based on her anatomy. Dr. Bernstein's testimony addresses a zero risk of injury, but this does not impose a standard of perfection. Dr. Bernstein's zero risk theory was stated in context with the ideal circumstances described. I quote from page 23 of the trial decision, "The rate of injury to the ureter in a case like Ms. Armstrong's, which had no abnormality or disease process increasing the risk of injury, should be zero. Dr. Bernstein accepted the 0.15% to 0.66% risk of injury to the ureter during a colectomy reported in the literature, but his testimony was that there should be zero risk in this particular case. Without any other potential reasons to make the surgery more difficult, there should be a zero risk of injury to the ureter because there should be no reason to be anywhere near it. Given these facts, the argument is not to hold Dr. Ward to a standard of perfection, but only to hold him to the standard that was laid out by the expert testimony. As there was nothing hindering him from following these steps accurately, Dr. Ward failed to meet the standard of care when he failed to stay 2 millimeters away from the ureter."
Counsel, sorry to cut you off.
No problem.
If we're doing are we not asking then for a standard of perfection? Essentially by saying that if injury results, you have auto breached the standard of care and sort of putting the horse before the carriage there with causation and taking in a circumstantial evidence of the situation in order to find that a breach has occurred when we should be focusing on the steps first. Sorry, that's about 2 or 3 questions in there.
That's okay. Thank you, Justice. So we will be addressing the causation as a circumstantial evidence argument later on, but to answer the question currently, what we are trying to point out is that it's not being informed by the outcome. It's not, the standard of care is not being informed by the fact that the injury occurred, but it is being informed by the fact that there was a necessary step, and this necessary step was to stay 2 millimeters away. So it was not something to try your best to do. It was not hope for the best situation. It was a situation where all experts said 2 millimeters away is a necessary thing that you need to be away from the ureter. And we also believe that 2 millimeters is not too high of a standard. It's extremely, extremely small. So in order to be 2 millimeters away, you just have to be a little bit away from the ureter. 2 millimeters is like that. So we'd like to point out that it is the step. This is part of the step. It's not a consideration of being a goal or any of like that. It is a step to be away from the ureter. Okay, so to continue, finally, for this submission, there's no evidence provided that if a surgeon tried to reasonably take the steps, they could still ultimately come within 2 millimeters of the ureter. So no experts identified that this was a possibility. In fact, and as mentioned, the expert testimony highlighted that staying away from the ureter was in complete control of the surgeon, especially in such ideal circumstances as Dr. Bernstein laid out. Therefore, based on the evidence before the trial judge, to stay more than 2 millimeters away from the ureter was a necessary step and not one that was far-fetched and reflected a standard of perfection. Based on these findings, Justice Mulligan appropriately characterized the standard of care in using a ligature device near a ureter during a colectomy and therefore was correct in finding Dr. Ward to have breached the standard in a way that he failed to stay 2 millimeters away from the ureter. Moving forward to the second issue at hand, we put forth that causation can be used as circumstantial evidence to inform the standard of care in this particular case. There is no disagreement between the trial judge and the Court of Appeal that the common law supports instances that require causation to be used before a standard of care analysis. In some cases, it is necessary to determine what happened in order to determine whether the standard of care was breached. This is not determining but for causation, but rather it is to determine factual causation. So in other words, on the facts, we examine and determine how the injury did occur. This is supported by the case law. In Kennedy and Jackowitz, the court held that it is open to experts and the courts to draw inferences of fact. It may be appropriate then for an expert or the court to infer from the nature of this injury what it was the surgeon did. So firstly, it's important to address the discrepancy between the trial judge and the Court of Appeal in relation to this issue. The Court of Appeal did not disagree that causation can be used before a standard of care analysis in some cases. However, the Court of Appeal believed this was only necessary in this case because of the trial judge's alleged misapplication of the standard of care. As already argued, the standard of care was applied correctly by the trial judge. Now I will address this case was a situation where causation could be used as circumstantial evidence to inform the standard of care. I would like to draw a distinction between causation being used as circumstantial evidence to inform the standard of care and the idea that the standard of care is being informed by the outcome. The latter is not what is happening in this case. The difference between the two ideas is nuanced but important regardless. What is of argument in this case is that in trying to determine if the standard of care was met, causation can be looked at. So let me draw two differing questions here to further explain. For instance, when determining what the standard of care is, the question to ask is plainly, what is the standard of care? To find the answer, the common law will highlight what a doctor needed to do. This is not an instance that can be determined by causation, and this is not the instance that we are arguing should be determined by causation. This is to say the standard of care would be informed by the outcome, and as mentioned, this is not what we argue. A separate question to ask is, was the standard of care met? To find the answer, the court would look at if the doctor actually did the things that he was supposed to do. For this question, it can be necessary sometimes that the factual causation is used to answer if the standard of care was met. We are looking at if the doctor actually did the things or actually took the steps that he was supposed to do. Now that I have drawn the distinctions, I would like to return to the facts of the case. Justice Mulligan had to rely on circumstantial evidence, including the nature of the injury, in order to determine how the injury occurred. This was done to then determine if Dr. Ward had breached the standard. Justice Mulligan was offered two explanations on how the injury occurred. The first explanation was that Dr. Ward brought the ligature 2 millimeters to the ureter, causing the thermal injury. The second explanation was that Dr. Ward did stay 5 to 15 centimeters away, but caused the scarring regardless, which then traveled through the abdomen and caused damage to the ureter. Given the competing evidence, Justice Mulligan had to resolve what really happened. Specifically, Justice Mulligan needed to determine whether the ligature was indeed 2 millimeters within the ureter, determining if that is what caused the injury. Justice Mulligan chose to accept the expert evidence that deemed that the ligature had to be brought within that close proximity, in other words, 2 millimeters, in order to cause a thermal injury. Justice Mulligan properly weighed the evidence given to him and ultimately sided with the plaintiff's experts, something he was entitled to do. As well, Justice Mulligan found no supporting evidence for the defense's expert theories. Given the competing theories, causation therefore bore directly on whether or not Dr. Ward had maintained an appropriate distance, and in turn, if he had breached the standard of care or not. Justice Mulligan would not have been able to determine whether there was a breach of standard of care without first using the circumstantial evidence of the thermal injury with the expert testimony to determine what actually happened. Therefore, in the circumstances of this case, using causation to determine whether the standard of care was breached was the correct approach. To summarize our two submissions is to say as follows. Justice Mulligan did not err in applying the standard of care. He did not apply a standard of perfection, and he did not characterize it as a goal of the case. He appropriately characterized the standard of care as necessary steps that needed to be taken, and such steps included being 2 millimeters away from the ureter at all times. Furthermore, this is a case where causation as circumstantial evidence was appropriate in informing the standard of care. Given that there were two competing theories, Justice Mulligan had to use the evidence to determine what caused the injury first, to then determine if the standard of care was breached. Thank you for your time, and my co-counsel will now deliver the appellant's final two submissions. Good morning. My name is Caitlin Simone, and I will be representing Ms. Armstrong alongside my co-counsel Kapetaneas. I express the same sentiment as her on the importance of this case and the implication it holds on our client, Ms. Armstrong. My first submission will address whether the plaintiff has the duty to rule out non-negligent causes. I will then proceed to my second submission on whether the majority erred in applying a correct standard of review, and if so, what the appropriate standard of review ought to be. At the Court of Appeal, Justice Pacheco, writing for the majority, stated that the trial judge should have dismissed the action because the plaintiff had not excluded non-negligent causes of action. Specifically, he stated that a plaintiff whose liability theory is that only negligence could have caused the injury in question is obliged to demonstrate that this is so, and that the trial judge is required to accept this before finding liability. Let me make this clear. Ruling out non-negligent causes is not the burden of the plaintiff. In negligence law, it is the standard practice that the plaintiff has to prove a prima facie claim, and then the burden shifts to the defendant, who now has a duty to respond. There is no such responsibility for the plaintiff to rule out non-negligent causes. This duty of the plaintiff is out of scope. To expand this duty would be erroneous to what negligence law stands for, that being to ensure and protect the plaintiff from wrongdoings that bring liability in law. I will bring your attention to the case law that supports this proposition. In Cooper v. Flood, the Alberta Court of Appeal ruled that when there is circumstantial evidence of negligence, the burden shifts to the defendant to produce counter evidence of non-negligent causes. This principle is in line with the reasoning that is seen by Justice Mulligan at trial. I would like to also note that in the dissent at appeal, Justice Van Rensburg states that the onus on a plaintiff in a medical malpractice case is not to disprove every possible theory that might be put forward by a defendant, let alone theories that are not raised at trial, but only on appeal. We have to think of it like this. If this were to be the case where the appellant was responsible for ruling out every non-negligent cause, this would lead to absurd consequences and would use the resources that our legal system cannot afford to waste. It would also require the plaintiff to make the defendant's defense. This would place a hardship on the plaintiff that is not appropriate given the pain they have suffered thus far in this taxing process. With that said, it would have been an error to require the trial judge to disregard Dr. Bornstein's testimony, the witness for the plaintiff, because he did not address fictitious non-negligent causes. It is a known fact that the nature of the adversarial system in our courts holds the expectations that both parties will put their best foot forward. In this sense, parties and counsel decide what to include in their case and what not to include based on strategy or the goal they are looking to obtain. This allows for autonomy, which is what our legal system stands for. With that said, for a plaintiff to bear the responsibility of demonstrating possible non-negligent causes when none were raised by the defendant would require the plaintiff to hinder their own case. Additionally, in regard to speaking about medical malpractice, it is the defendant who is in the greater place to make claims regarding non-negligent causes. Expecting a patient to specify how a doctor was negligent may create a power imbalance, since they usually cannot know what happened during the surgery. In this case, the defendant, who is a medical expert, who actually conducted the procedure, can easily claim ignorance of how the injury occurred. Additionally, I'm unaware of how Ms. Armstrong would be able to answer for possible non-negligent causes, as she was under anesthesia, resulting in her being unconscious when the event took place. Moving on, it is not the duty of the courts to decide what one party should have included in their argument. It is a common principle that judges must decide cases on the evidence presented to them at trial alone. Judges are not to speculate, rather they must make decisions solely based on the evidence before them. Respectfully, this applies to disagree with the majority's decision, which, as mentioned before, was that a trial judge who's prepared to proceed on the basis that only negligence can be the relevant injury is obliged to consider and rule out other non-negligent causes. The case law of Hassan v. Avenari additionally helps to support this principle. In this case, it was ruled that a trial judge is not obliged to consider potential non-negligent causes when there is no evidentiary foundation to do so. This can be seen in our case. The trier of facts is required to determine the standard of care and its breach based on the evidence and not on speculation. In application, it was not up to Justice Mulligan to rule out non-negligent causes, as there was no evidentiary basis before him to make these in regard to the injury of Ms. Armstrong. In Philip v. Ford Motor of Canada, the expectations of the adversarial system are laid out as follows. This procedure assumes that litigants, assisted by their counsel, willfully and diligently present all the material facts which have evidentiary value in support of their respective positions, and these disputed facts will receive from a trial judge a dispassionate and impartial consideration in order to arrive at the truth of the matters in controversy. A trial is not intended to be a scientific exploration with the presiding judge assuming the role of a research director. It is a forum established for the purpose of providing justice for the litigant. In the case at issue, there was no expert testimony accepted by the trial judge that provided non-negligent reasons for a surgeon to use the ligature within 2 millimeters of the ureter. I repeat, it is not the role of the judge to make speculation. With that said, the majority respectfully erred in its claim that the trial judge should not have accepted Dr. Bernstein's evidence because he did not raise and rule out possible negligent causes. Moving on to our last issue. It is our finding that the majority failed to give deference to the trial judge's finding of fact. The purpose of a standard review is not meant to exist to overturn a trial decision owing that the court entertains a different interpretation of the facts before them. This is because a trial judge is in the greatest position to assess credibility as they occupy a privileged position in assessing the demeanor and evidence of witnesses and what credibility and weight of law they should be given. The only time where it will become suitable for an appellate court to intervene on this matter is when the assessment of credibility is based upon misapprehension of evidence or displays a large error. At trial, this was not an issue. The judge makes findings of facts that were reasonable based on the evidence before him. With that said, respectfully, the conduct of the majority of appeal was an overstep. They did not respect the deference owed to the trial judge on his determination of fact and preference for one expert opinion over another. It is clear that the Court of Appeal overturned this decision because they took a different view of the evidence before them. This is very problematic and is outside their scope as adjudicators. At the Court of Appeal, the majority states that if the trial judge expressed his finding on the standard of care in a less ambiguous fashion, they would have agreed with his decision. Respectfully, this is also problematic. The Court of Appeal acknowledges that what the trial judge is attempting to say is correct, but the way in which he does communicate his message is incorrect. Due to the complexity of this case, and the many factors involved, they are holding the trial judge to an unfair and mistaken level of perfection. So those are our arguments. Thank you.
So I would just ask quickly, what is the standard of review that you think would have been appropriate in this case?
So the standard of review that would have been appropriate is a standard of reasonableness. This means that a court has to look at whether the decision made was reasonable. There can be more than one reasonable outcome, but courts have to accept any decision that is reasonable. And to us, the decision that the trial judge made was reasonable, and they overstepped their role in coming to their conclusions on non-negligent causes and other expert witnesses.
And let me ask also, can we consider that this was just a case that Dr. Ward performed a complex procedure and there were undoubtedly issues of complication which can arise in such a complex surgery as this one?
Sorry, can you repeat the question?
Yeah. Can we not also consider the fact that Dr. Ward performed a complex procedure in this surgery and there are issues of complication that can arise? Therefore, I mean, I'm asking about the standard of care and, causation and that.
Well, the standard of care exists for that reason. It's not an unreasonable standard of care. That's definitely taken into consideration. The anatomy of the appellant was normal. She didn't have a specific anatomy that would result in complications arising. So I think that's important to take into consideration when looking at the standard of care and what the standard of care should have been.
Okay, if there are not any more questions, the court now invites counsel for the respondent to begin.
Thank you, and good morning, Chief Justice and Justices. My name is Lauren Thompson. Today we have split our submissions this morning between myself and my colleague, Julian Tanzer. I will address the standard of care claim for 15 minutes. My co-counsel, Jillian, will address the standard of review, non-negligent clauses, and conclude our submissions. Does the panel require a recital of the facts?
No.
Thank you. So I do plan to address 3 arguments today. First, that Dr. Ward was reasonably prudent during Ms. Armstrong's surgery. Second, that causation should not be used to inform the standard of care. And third, that the trial judgment erred with respect to defining the standard of care. So first, Dr. Ward was reasonably prudent during Ms. Armstrong's surgery. The judge measured Dr. Ward's liability according to the goal a reasonably prudent surgeon would have had when conducting the operation, rather than the means a prudent surgeon would use to attain that goal. The trial judge determined Dr. Ward's negligence by inquiring whether he succeeded in not coming within 2 millimeters of Armstrong's ureter with the ligature, instead of asking whether Dr. Ward took the steps that a reasonably prudent surgeon would take. The judge did not find that a ligature could only be brought within 2 millimeters by negligent acts or omissions. The complainants alleged, yes.
Can what happened have any influence on the definition of standard of care? In other words, can you determine standard of care and whether or not it was breached without considering what actually happened?
Sorry, can you clarify the question?
So, I mean, we know, so knowing what has happened, can you consider whether or not what has happened in this situation, whether or not that should have any sort of impact or influence on the standard of care, and then determine it in that fashion?
Yes, this can be the case. The reason for this is the method that occurred. So while I will mention about how causation should not be used to inform the standard of care, the standard of care can't be based on hindsight, result-based reasoning, or a standard of perfection. And this plays into the facts itself, because the complainants today allege that the trial judge found Dr. Ward did not take the necessary steps. However, the trial judge did accept that Dr. Ward took the necessary steps to identify and protect the ureter. So at paragraph 109 of the trial decision, the trial judge said, "I'm satisfied that Dr. Ward took the steps during this laparoscopy to identify and protect the ureter." He explained those steps and testified that he kept at least 5 centimeters away from the ureter. Despite that finding, the judge found liability on the result. So the Court of Appeal majority allowed Dr. Ward's appeal and held that the trial judge erred in his analysis of the standard of care. This is because the trial judge improperly established a standard of perfection and erred by defining the standard of care as a goal rather than analyzing the reasonable means to be employed to achieve that goal. So it should have assumed liability based on whether Dr. Ward performed the operation in a manner that was a reasonably prudent surgeon would have. The trial judge confirmed Dr. Ward took the required steps of a reasonably prudent surgeon. These were also confirmed by the complainant's expert. Regarding the fact that causation should not be used to inform the standard of care, first, the standard of care cannot be based on hindsight, rules-based reasoning, or the standard of perfection. And second, the policy is consistent throughout professional liability law. So Justice Pesciascio discussed the burden on the plaintiff to raise non-negligent causes that a trial judge ought to consider before determining liability. Courts must be careful to assess doctors for the standard of care at the act and not at the time of the trial. The law must consider the medical man must possess and use the reasonable degree of learning and skill ordinarily possessed by practitioners in similar communities in similar cases. This involves a locality rule, and physicians are not held to a standard of perfection, distinguishing errors in judgment and negligent conduct. So we agree with the complainants that all evidence before this trial is circumstantial. It's so circumstantial, in fact, the complainants conceded today that there were multiple possible ways this injury could have occurred. There is a difference between having a surgery go wrong and holding a physician professionally found negligent. The standard of perfection is...
I'm going to cut you off there. Sorry, counsel. Isn't it the job of defense counsel, as your friend suggested, to present the best defense possible? I mean, they did give 2 expert reports outlining 2 other ways that this could have happened, but both of these were rejected by the court. So doesn't it seem that the only logical conclusion was that this was how the injury occurred? Like, why should the onus be on the plaintiff to rule out every single hypothetical possibility of what occurred?
My apologies. So the trial judge did in fact find that these two methods were both equal possibilities. So the trial judge did find that there were multiple ways that this could have occurred. We will further discuss it in Jillian's section as well, but essentially the standard of perfection is throughout the trial decision because it asks the surgeon not only to take the steps to protect the ureter, but also execute the surgery perfectly. There's never a zero risk surgery and there's never a perfect patient. Just because one doesn't have obvious risks doesn't mean that they don't have underlying health conditions or that complications will not occur. There's also no burden of proof on a defendant to prove their innocence. But the trial judge did find Dr. Ward took all reasonable steps and still came within 2 millimeters of the ureter. Second, the policy is consistent throughout professional liability law. While the impact to the plaintiff is immense, not every act that creates a risk constitutes negligence when an injury occurs, and not every act that creates a risk constitutes this negligence. Surgery has inherent risks.
I just cut you off for just one moment with a question. So I understand that your position is that there's no perfection on doctors, but what will be the implication on future patients if we're not holding a specific high standard, especially if we're not considering patients that have less risk or they're considered to be, in a better position to undergo these type of surgeries. So I understand that it is your position that we wouldn't look at non-negligible causes, but what comfort do we get for the population if we're going to rule in this favor?
Absolutely, Ms. Palis, we completely agree and understand that. Here, the fractional matrix is different than what you may see in other cases. Here, it's not a clear case of this awful negligence like a sponge in the body. This is the case where even the injury is not necessarily determinable. The surgeon took all reasonable steps. Had the surgeon not take reasonable steps, this is where negligence could occur. But there is a difference between a high standard of perfection, and there's complications with surgeries, so you can't expect perfection. But being reasonably prudent is enough. So the conduct is only negligent if deemed objectively unreasonable. First, the defendant must be the factual cause of the plaintiff's loss, which involves determining whether the injuries would have occurred but for the defendant's negligence. Second, the defendant must have been the legal cause of the plaintiff's injuries. A health practitioner need only demonstrate a reasonable level of care. The Supreme Court of Canada says that an error in judgment has long been distinguished from carelessness, unskillfulness, or lack of knowledge. This is the honest and intelligent exercise of judgment has long been recognized as satisfying these professional obligations. The problem with using causation as a standard of care is that causation can be found in almost any med-mal case. As the defendant was the direct cause of the plaintiff's injuries, using this to inform standard of care would create a reverse onus on defendants to prove they are not guilty in a court of law against accusations of patients. And similarly, in Resurface Court and Hinkey, the court found that while a material contribution test has been used rarely, the but-for test is necessary. Applying a causation analysis before standard of care is circular logic. As the defendant's conduct, as the defendant's conduct sustained by the plaintiff from the breach would be compensable. Whether the breach of duty actually caused the plaintiff's injury would never even be addressed. So in other words, in medical malpractice, creating a reversal would mean it would be up to the defendant to show that an injury occurred in another way, that the area of risk to escape the burden. Complainant's edition of Kennedy held that the court may infer from the nature of the facts, but the cases so far where the burden of proof was reversed were only in extreme cases with undisputed facts. Here, the trial judge had not one but two explanations of the possibility of how this event occurred. The expert evidence the trial judge weighed was from an expert that doesn't even conduct these surgeries using laparoscopic methods, which was admittedly a completely different surgery and method. So considering the principle of fairness to the defendant is similar to the Supreme Court's notion that fairness to the plaintiff requires a principled approach of causation. The court has lowered the standard test where it would offend the basic notion of fairness and justice to deny liability by applying a but-for approach. However, applying a material increase in risk approach to causation could result in a similar injustice to the defendant who only may have injured the plaintiff by increasing the risk of injury. Thus, a principled approach to standard of care causation must be and has consistently been maintained by the courts. Causation cannot be used to inform standard of care. So third, the trial judge erred in defining the standard of care. So the Court of Appeal correctly identified the trial errors here. At the Court of Appeal case, they said the trial judge applied an improper standard of care that would have held the surgeon to a standard of perfection. Rather than focusing on the goal of the operation, the trial judge should have focused on the means used by the surgeon. The surgeon took precautions to avoid injury to the patient, and it was not proven that his actions in this area were deficient. In fact, the trial judge acknowledged that the surgeon had acted with reasonable prudence. Without evidence of a breach of the standard of care, the finding of liability could not stand and the action was dismissed against the surgeon. So in this case, deployment within 2 millimeters of the ureter was a goal or result to be pursued. The trial judge accepted that Dr. Ward took the steps to identify and protect the ureter. Despite that finding, they predicted liability on result, and this was an error of law. Having found that Dr. Ward took the steps that a prudent surgeon would take during the surgical procedure, the judge should have found that it was not proved that Dr. Ward breached the requisite standard of care. Had the judge properly conceived of the standard of care, it would not have been necessary for him to have conflated causation and standard of care decisions. This error was inextricably linked to the judicial outcome. So thus, first, Dr. Ward was reasonably prudent during Ms. Armstrong's surgery. Second, causation should not be used to inform the standard of care. And third, the trial judgment erred with respect to defining the standard of care. So this concludes my submissions. Pending any further questions, I would like to pass my submissions to Jillian Tanzer, who will address our standard review, non-negligent causes, and conclude our submissions.
Thank you and Thank you and good afternoon, Justices. My name is Jillian Tanzer. As my colleague has mentioned, the issue I will be addressing today is that of the obligation of the trial judge to rule out non-negligent causes. This refers to the Court of Appeal's majority decisions in paragraph 46 to 58. And time permitting, I will touch on the Court of Appeal using the correct standard of review correctness. It is our position on behalf of Dr. Ward that the Court of Appeal correctly identified the circumstances in which it is appropriate for a trial judge to rely solely on an injury to define the standard of care. Further, in order to do so, the trial judge ought to consider and rule out non-negligent causes. The analysis I will take you through only arises if you accept that the trial judge made an error in defining the standard of care in terms of injury. If you are not convinced of that the trial judge made such an error, then this analysis will not apply. It is our submission that the majority of the Court of Appeal did not create nor overturn existing law. Instead, the majority sought to clarify the narrow circumstances in which it is permissible for a trial judge to define the standard of care based on injury. As mentioned in paragraph 42, for the reasons of the Court of Appeal, the general rule is that it is an error of law to use outcomes or goals as the standard of care. Further, negligent standards of care are to be measured by the behavior that a reasonable, prudent person would undertake, rather than the results that a prudent person would seek to attain or to avoid. The Court of Appeal goes on in paragraph 46 to say that this is simply a general rule, and therefore there are limited exceptions where an injury alone can define the standard of care. I quote paragraph 46. I have described the bar on defining standards of care according to goals or results as a general rule because I will not rule out that there are cases where negligence alone could prevent a goal from being achieved or a positive result from being attained. The majority then goes on to provide 2 examples of the limited exceptions to the general rule. First, that of leaving a sponge in a patient during surgery, and second, operating on the wrong limb. These are clear examples where evidence could show that it is only through negligence that the outcome could happen. The difference between these cases and the one in front of us is that the means for preventing this type of injury in the examples I just mentioned are very well established, and therefore it would be harmless to define the standard of care as outcomes or goals instead of prudent means or behavior. For example, it would be acceptable to find that it is a breach of the standard of care by leaving a tool in a patient or removing the wrong limb. As the
Sorry. Well, can I ask you though, so can the what happens though have any influence on the definition and the standard of care? So can you not determine the standard of care and whether or not it was breached without actually considering what happens?
I think in certain cases like that, the examples I just gave, it would be appropriate to look at what happened. But in cases such as the one in front of us today, it wouldn't be as appropriate. So
even though in this case that the patient had no comorbidities and she was completely healthy?
No, because there was other theories put forward at trials to show that there are other ways in which you can breach the standard of care of how this injury could occur. Sorry. So it wouldn't be as clear cut as the examples I just mentioned. It's not you leave a sponge in a patient, okay, you're liable. That's clear, well-established negligence. Instead here, it's not as clear. There are reasonable steps that need to be taken. And the trial judge had found that Dr. Ward had made those steps. So I think that these cases can be differentiated.
Thank
But
I have a
isn't it
further
correct?
question on that.
Sorry, yeah.
Oh.
All right, so if a patient presented with a large tumor in her colon or inflammation stemming from Crohn's disease or colitis, would there be any dispute that the standard of care was breached?
So sorry, I'm just trying to make the.
So she presented with a large tumor or inflammation stemming from Crohn's disease or colitis. Would there be any dispute that there was a breach of the standard of care?
Would there be a dispute? Sorry, I'm just trying to think about it. I don't think so, because I would say no, because the steps were still taken. The trial judge had still found that Dr. Ward had done the appropriate steps to identify and protect the ureter. So if the trial judge had made that finding, it's still our position that there was no breach. Are there any other questions? Okay. As the majority stated, the surgery in question was highly complex and involved multiple specific steps. This, therefore, again, is reason to differentiate this case from the examples I had just mentioned. Therefore, it is highly unlikely that this case would fit within the limited exceptions to the general rule, and therefore, injury alone cannot define the standard of care. If, however, we are going to assume that the court does find that it fits within the narrow exceptions, the plaintiff failed at discharging their burden as they did not bring forward any non-negligent causes. Therefore, in this case, the plaintiff simply did not provide enough evidence, and therefore the trial judge was left with insufficient evidence to rule out non-negligent causes. In response to the
Again, I have to ask, why should that be the burden of the plaintiff? I think that's the point that I'm struggling with the most today. Like,
No,
why? I mean, the defense knew that they had to counter evidence and present alternate theories. They had 2 expert witnesses to do this. Why could the burden not be on them to suggest
I think, yeah,
non-negligible causes could have interacted here?
I think the first thing that we have to acknowledge is that the plaintiff chose the route of saying only negligence could have caused this injury. So if they're going to make that case, they ought to provide evidence that that is what happened. And again, we just want to make it clear that we're not asking the trial judge to go outside, do extra research, make speculations to rule out non-negligent causes. We do think that it is to the plaintiff, if they make their case that only negligence can cause this injury, then they ought to provide that evidence, because otherwise it's kind of like a strict liability that we would find ourselves in. Further, in the appellant's factum in paragraph 23, they have argued that patients who are under anesthesia, such as Ms. Armstrong, are not in a position to answer for possible non-negligent causes, and therefore Dr. Ward would have been in a better position to make those claims. However, it is our position again that Ms. Armstrong could have brought forward expert evidence on the matter. It is open to the plaintiff to pinpoint a negligent act or omission through expert evidence or otherwise. If we do not rule out non-negligent causes, then again, we are defining the standard of care through strict liability. Essentially, if you come within 1 to 2 milliliters, you will be liable. And if the court is willing to accept this, you have to be satisfied that this could only occur through negligence and no other possible causes. This is something that the trial judge ought to make a finding of through the plaintiff's evidence. Therefore, it is our submission that there was insufficient evidence for the trial judge to make the conclusion that in every case, there is negligence by becoming within 1 to 2 milliliters of the ureter. Further, there is no evidence that it could only be by virtue of negligence that you come within 1 to 2 milliliters. To conclude on this point, an injury alone will not prove negligence unless in exceptional circumstances that are analogous to the ones I explained earlier. This case does not fall within those exceptional circumstances. However, it would have been up to the plaintiff to demonstrate that her case falls within the limited category of exceptions. But
I just want to interrupt you quickly. My apologies. So is it your position that we should only be looking at those analogous cases to make our finding?
I think those analogous cases were just examples, but because it's so clear that only negligence could have caused that to happen. Whereas in this case, it's not so clear. We did have other expert opinions on how this could have happened. So therefore, it's not one reasoning, and that makes sense. And the court is confident that it could only happen through negligence. So I wouldn't limit it to those two examples that I did mention, but cases that are analogous to those would make the most sense.
Thank you.
As a result of the trial judge and the plaintiff failing to bring forward evidence, it was an error for the trial judge to find negligence without sufficient evidence that ruled out the non-negligent causes. Now I will quickly touch on the standard of review. It is uncontentious that the appellate standard of review for questions of law is that of correctness, and the standards for questions of mixed fact and law is that of palpable and overriding error. A finding of negligence is typically a question of mixed fact and law, and therefore the standard will be on a spectrum. However, where there is an error of finding of negligence that is attributed to the application of an incorrect standard or similar error, this error will be characterized as an error of law and therefore subject to the standard of correctness. The Court of Appeal attributed the error of the trial judge to the incorrect definition and application of the standard of care. And therefore, this is characterized as an error of law and subject to the standard of correctness. Therefore, the Court of Appeal made no error in applying the standard of review. And that concludes my submissions. Pending any other questions, I thank this court for its time and questions.
We have some follow-up questions for the appellants. Are we able to ask?
Yes, the judges have the option to extend any of the sessions for an additional 3 minutes if so they choose.
Unless, I don't know whether anyone was going to do any rebuttals.
There is a 3-minute rebuttal for the appellants.
Okay.
So if anyone would like to ask their questions, after the rebuttal, they are more than welcome to. We can extend the 3 minutes by like an extra 3 minutes just for questions, if that's all right with everyone. Okay, that's great. The court now invites the counsel for the appellant to begin their optional 3-minute rebuttal.
Thank you. For our rebuttal today, we would like to address just a couple of the arguments stated by our friends. We would like to respond to the standard of care arguments as well as the causation arguments. So to say that it is just the reasonably prudent steps that need to be taken, and to say that there has been too high of a standard means that a surgeon can apparently meet their duty by taking some, but not necessarily all of the required steps in the medical procedure. This can have high consequences in policy and high consequences for plaintiffs. To say that because he tried to take the reasonably prudent steps and to leave the plaintiff unable to make a case despite the immense consequences she has had to face is unfair and unjust. We would like to reiterate that we are characterizing on the word trying. It is not enough to try to take the reasonably prudent steps. The steps need to be taken accurately. So the trial judge stated that Dr. Ward had taken the 2 first steps, but he was not successful in taking the last step, which is to stay away from the close proximity at all times. In this way, Dr. Ward was not reasonably prudent. Furthermore, the trial judge did not predict liability on the goal or the result. The trial judge weighed the evidence before him and chose to accept Dr. Bernstein's evidence and chose to reject the defense's expert theories. Given the thermal injury and the expert testimony, the trial judge was entirely entitled to infer that the injury occurred with the ligature being too close. Finally, we'd like to reiterate that given that there was no evidence provided that if a surgeon tried to take the reasonable steps, they could still come within 2 millimeters of the ureter, and no experts identified that this was a possibility, we believe that the trial judge was correct. In fact, and as mentioned, expert testimony highlighted that staying away from the ureter was in complete control of the surgeon, and again, we'd like to reiterate in the complete ideal circumstances that were prevalent in this case. As well, as we have mentioned, the defense expert theories were unaccepted. We believe that this is enough for the trial judge to weigh back and forth what he believes is to be accepted and what is to not be accepted. That is the role of a trial judge in a case, and he is entirely entitled to do what he has done. The trial judge, based on all this evidence and without the evidence demonstrating other causes, such as non-negligent causes, he was fair to make the inference that this was, in fact, what caused the injury. As well, we reiterate that it was not the plaintiff's burden to show non-negligent causes. Therefore, based on the evidence before him, the trial judge allowingly made his inferences. Determining what caused the injury, the trial judge was then allowed to relate this to the standard of care. With the standard of care being to stay away from close proximity of the ureter, in other words, 2 millimeters, and if the injury then, based on the evidence, was determined to have been caused by being in close proximity, we cannot see how Dr. Ward could not have been seen to breach the standard of care. Thank you.
Counsel, I just have to ask, based on some points that came up in your friend's submissions, didn't the trial judge accept that the doctor stayed away from the ureter by 5 millimeters? And also, just to touch a second point on that, I really liked their idea that you're now forcing the defendant to prove their own innocence. And so how do you reconcile these 2 issues?
Yes, so for the first aspect of that question, it is, sorry, can you repeat the first part of the question?
So the first was it not found that the doctor stayed away by 5 millimeters? And so therefore, didn't he satisfy the standard of care?
Thank you. I believe that it was found that he tried to protect it. So he took the reasonable steps to identify the ureter, and he took the reasonable steps to try to protect the ureter. And what happened with the competing theories is that he claimed that he stayed 5 to 15 centimeters away. And the injury, based off the expert testimony, could not have occurred without being as close as 2 millimeters from the ureter. So based on the mass discrepancy, 5 centimeters to 2 millimeters is quite a ways away, especially in scientific and medical care. The trial judge rightfully inferred that he must have been 2 millimeters, at least close proximity to the ureter. And do you mind repeating the second question as well?
Certainly. So that was just more getting to the point that because there is likely no alternative, are we now not putting the burden on the defendant? Well, there's strict liability, you're automatically guilty, and now you have to prove your own innocence and try and come up with another suggestion for what could have occurred?
Sorry, and on that, I'm going to, expand upon that question, which if you don't mind me asking, and in that effect, then will assessing causation first result in bias when determining the standard of care and like that strict liability issue?
Am I allowed to jump in, or does it just have to be my other co-counsel? I'm not allowed to jump in.
Go ahead. Feel free.
Okay, go ahead. I was just going to address the first question and then Theone can go back to the causation question, but in regard to what you were saying about it would have to be the plaintiff who would have to prove the non-negligent causes. I just don't understand how it would be in the position of Miss Armstrong to prove that. She can't, she doesn't have, it would be a overstep of power. She's not in the position.
Apologies, counsel, as that was not the question. Definitely recognizing that Miss Armstrong is not in a position to be able to come up with that. I just was interested in hearing your thoughts on the alternate side of this argument, that aren't you also now imposing that same unfairness on the defendant to come up with any sort of rationale for what could have happened? I'm just trying to recognize that there are competing interests here, and I'm interested in hearing your thoughts on that.
Well, I do recognize that maybe there would be a hardship on the defendant to prove that. I don't see another system that can exist where the plaintiff and the defendant are meeting at ends and trying to find a reasonable solution to their case. This is the system that has been used in many case laws, and to override the system would be a very huge overstep into the common law.
I can take the second question from Justice Shore. So in regards to the causation, we do understand the concern that it could inflict bias. However, we'd like to reiterate that Justice Mulligan did not base his finding essentially on the results. He laid out the steps based off expert witnesses that it was to 1, identify, 2, protect, and 3, stay away, close proximity, meaning 2 millimeters away from the ureter. Once he had this standard of care, he was unable to come to the conclusion on what occurred without looking at the competing theories and weighing the evidence. So once he took the competing theories, he weighed the evidence. Causation entirely bore on the results. We had to learn what happened, what actually occurred in this case in order to find out, yes, he identified, yes, he protected, but in order to identify if that third step was taken, that close proximity was taken. So though we do recognize that in cases it could come out as bias, and we recognize that in most cases and most often, it is standard of care analysis that should be done first in order to avoid that bias. There are some cases, however, that we cannot find out if the defendant had breached the standard of care without first looking at what happened, and this is one of those cases.
Okay, just for transparency's sake, I looked at the rules again, and it was an extension of 5 minutes. So I went ahead and extended those 5 minutes. I added another 2 minutes to the 3. Thus concludes the matter of Armstrong and Ward. It was a pleasure to moderate this event for you, and I would like to invite you guys to all stay for the next session. It is starting at 1. We are a little bit ahead of schedule, but thank you so much for all of your time. It's much appreciated. Great job, everyone.
Thank you very much, everyone. Very impressive.
Thank you.
Thank you.
Thanks, everyone.